Estate planning for older clients can be complex, especially when considering the implications of Medicaid known as MassHealth in Massachusetts, nursing home liens, and irrevocable trusts. Attorneys in Massachusetts must stay updated on the evolving regulations and case law surrounding these matters to offer the best protection for their clients. This article explores some of the critical elements of Medicaid regulations, estate recovery, and irrevocable trusts, focusing on how to protect assets like the family home from MassHealth claims. Medicaid is a joint federal-state program designed to assist with healthcare costs for individuals with limited resources. In Massachusetts, the program is called MassHealth. Attorneys must be familiar with both federal and state regulations to ensure that they are crafting an estate plan that aligns with Medicaid asset protection guidelines. The Medicaid program underwent significant changes with the passage of the Deficit Reduction Act, which I'll call the DRA, in 2005, which Massachusetts implemented retroactively in 2007. The DRA introduced stricter rules for Medicaid eligibility, including a 5-year look-back period for transfer to individuals and trusts, new rules for when ineligibility periods begin following asset transfers, requirements that annuities owned by Medicaid applicants name the state as a residuary beneficiary, and home equity limits for single applicants, which is currently set at a little over $1 million. These changes highlight the importance of planning well in advance for potential long-term care needs. Waiting until a health crisis arises could significantly limit an individual's options. One critical element of Medicaid planning in Massachusetts is protecting the home from potential MassHealth liens. Once an individual begins receiving MassHealth benefits, the Office of Medicaid, OM, may place a lien on their real estate, including their primary residence, to recover the cost of nursing home care or other medical care. Understanding the rules surrounding these liens is essential to advise clients on asset protection. MassHealth can place a lien on the home of a single person receiving nursing home care if a doctor certifies that the individual is unlikely to return. However, this lien is not automatically placed if a spouse or other eligible relative resides in the home. MassHealth typically refrains from enforcing liens until the recipient's death, at which point they seek to recover the costs through estate recovery. One way to delay the placement of a MassHealth lien is to ensure that the Medicaid applicant answers yes to the question of whether they intend to return to their home, even if it seems unlikely. This subjective answer, combined with a doctor's certification, can prevent the placement of a lien during the applicant's lifetime. However, this strategy only delays the lien. Estate recovery rules may still apply after the applicant's death. So how do we protect a home through estate planning? For most clients, their primary residence is their most significant asset that they own. Whether planning in advance or during a crisis, protecting the home from estate recovery is a top priority for Massachusetts residents. The law provides for several methods to shield a home from MassHealth liens, but each comes with its own set of challenges. So let's consider a hypothetical scenario. Mr. Jones is in a nursing home and receiving MassHealth benefits, while Mrs. Jones, his spouse, lives in their primary residence. In this case, the home is not a countable asset for determining Mr. Jones' Medicaid eligibility. However, what happens if Mrs. Jones predeceases Mr. Jones? If Mrs. Jones dies first, the house would revert to Mr. Jones as the sole owner, placing it at risk for estate recovery. To avoid this, one solution is to transfer ownership of the house solely to Mrs. Jones while Mr. Jones is alive. Since intraspousal transfers are permitted under Medicaid rules, this strategy would protect the home from immediate MassHealth claims. After Mr. Jones is approved for Medicaid, Mrs. Jones can then take additional steps to safeguard the home from her heirs, or for her heirs. Let's consider long-term solutions. Irrevocable trusts and life estates. Once Mr. Jones is approved for Medicaid, Mrs. Jones should consider transferring the home into an irrevocable trust or executing a deed with a life estate. Both options include a 5-year look-back period, so they should be implemented after Mr. Jones' Medicaid approval to avoid disqualifying them from benefits. An irrevocable trust is one of the most common tools for protecting assets from MassHealth estate recovery when structured correctly. Assets placed into an irrevocable trust are no longer considered owned by the grantor. However, drafting the trust requires careful attention to details to avoid pitfalls. Here are 3 essential rules for an irrevocable trust. Irrevocability. The trust must be irrevocable, meaning that the grantor cannot revoke or amend the trust once it's created. This protects the asset from being counted for Medicaid eligibility or estate recovery purposes. Trustee selection is important. Some attorneys believe that the grantor should not be serve as trustee. They reason that the grantor has control over the trust and MassHealth may treat it as a countable asset, jeopardizing Medicaid eligibility. In my opinion, this issue is resolved by a case called Guilfoyle versus Secretary of Executive Office of Health and Human Services. It's a case that the SJC found that the trustee of a nominee trust could be the person that settled it, and it wouldn't actually count as a countable asset. And finally, no access to principal. The grantor can't have access to the principal. The irrevocable trust should be like a lockbox holding assets safely until after the grantor's death, when the assets can be distributed to the beneficiaries and avoid estate recovery. While irrevocable trusts are a powerful tool for protecting assets from MassHealth claims, they must be drafted with precision to ensure compliance with an ever-evolving regulations. Attorneys should stay informed of recent case law and regulatory changes to provide their clients with the most effective solutions. And to conclude, estate planning for older clients, particularly those concerned about long-term care costs and MassHealth liens, require a nuanced understanding of both state and federal regulations. Attorneys must be diligent in crafting plans that protect clients' assets from MassHealth claims while also ensuring compliance with Medicaid eligibility rules. By using tools like an irrevocable trust and carefully structured life estates, clients can protect their homes and other significant assets from estate recovery, ensuring that they can pass their property on to future generations. If you have questions about this or anything else, feel free to call our office at 781-761-2148 or visit our website at cody-law.com, and I'd be happy to talk to you at a free consultation. Thanks.